May it please your Lordship, I beg to mention item number 11. Lordship, I'm praying for some accommodation as the senior counsel is indisposed, Your Lordship. He's not keeping well.
Excuse me.
No objection, Your Lordship.
On prayer made by Ms. Counsel for the petitioner seeking accommodation on the ground that the learned senior counsel Dr. N. Muzika is indisposed. Matter is adjourned. This system after 2 weeks. 2 weeks.
Much obliged, Lordship.
Please, Lordship, there is an item listed under the mediation column. Can we be allowed to mention?
No mention.
No mention.
It will be taken up. You see, today no formal order will be passed.
Understand.
Please, Your Lordship, I beg to make a mention of item number 19.
Hmm?
Item number 19.
No mention for item 12 and above. Matter will come up. But see, the purpose will be explained to the council.
Daily list item number 1.
Lordship, so on the earlier occasion also I have argued the matter, but it will take time, Lordship. What I am saying, Lordship, that if the matter is listed Friday, Lordship, so that my Lord is not sharing any division bench, Lordship. So because it will take time, Lordship, because in a hearing in a piecemeal, my Lords, earlier also twice the matter was heard. At least if some substantial time is spent on hearing, then that will be fruitful for the court as well as for the other side also, Lordship. So generally my Lord is not sharing the DB on Friday, Lordship.
No, Friday also we do have.
Because it will take time, my Lord, lots of. Later on I'll summarize the issue, Lordship. The issue is 3 and 4 issues are involved here. Whether my termination was as per law, whether any approval was taken, what is the role of the third party, Lordship, that the teachers who were appointed in my replacement, then I'll substantiate my argument with law points, Lordship, and citation. It will take time.
We'll have it on first.
First, yes, Lordship. That generally my lot is not sharing, Friday not sharing the DBA generally. First.
On previous by Mr. S.A. Sheikh, counsel for the petitioner. This is matter for the hearing on first.
Mass order. 228.
Same.
Same. Mass.
Item number 9.
May it please your lordship. Lordship, I'm humbly praying if this matter can be referred for mediation, my lord. I've spoken to Sir Mahanta, counsel for the cantonment board.
No, I don't have instructions. Since the mediation, let us try if something can be done.
अपनी तो कहाँ है तो कहाँ फॉर्मेट
It's not in the column for the matters to be
I
listed.
understand.
What you say?
We'll we'll consider this matter when we take up those matters for for referral. There's that portion from item 12 and below and above. We'll take up.
All right.
But if Lordship permit, because I have one matter there. Anyways, he'll be there.
One second.
Item number 10.
Morning.
Please watch.
Yes.
Rejoinder has been filed, Your Lordship, just for hearing.
For hearing, Lordship.
So we'll hear the matter.
Lordship will hear now?
Yes. What was the prime objection here?
Firstly, Your Lordship, that the applicant is not the accused and cannot sign the bail application. Second was that new grounds have not been raised, etc. And thirdly was primarily on technical grounds, that it's the embargoes apply, hence bail cannot be granted under UAPA. So these three were the primary objections raised by the respondent.
I don't think we'll have time today.
May I suggest, Lordship? If Your Lordship may take up the mediation matters first, and we can have this at the end of the board if time permits.
Yes. We'll pass over.
Wait, Your Lordship.
Lordship.
Item number 12.
See,
I don't have any objection
no,
here.
let me explain the. You have not even heard what the court has to say. There is a, I think this is, see, for the benefit of all the councils here also. In fact, we have also informed the Bar Association. Perhaps the members may be knowing this, that there is a special drive conducted by the Supreme Court of India to try and see that matters are being settled through mediation. And for this, we have this special drive that is going on now, and we have also tried. I'm not saying we with definity, but we have tried to identify certain cases which have some element of settlement. So what we have done is we have randomly listed the cases. Today and tomorrow, of course, there will be number of cases listed. But again, as far as mediation is concerned, it is for the parties to decide. We cannot force. Time and again I've said this, we cannot force the parties. If you are willing to go for mediation, presumably on the expectation that the matter will be settled speedily, that the matter will be settled to the satisfaction of all concerned. Because in mediation, we used to say in mediation, it is always a win-win situation. Nobody loses, nobody wins, everyone, in fact, everyone wins. As far as, going extra, taking into consideration the, relations in the parties. There are some cases which involve family dispute and this and that. So through mediation, even that aspect is also covered. So for that matter, what we have done is, as directed by the Supreme Court, we are listing these cases. If parties are agreeable, but of course you may have to get your client's consent for that. What we will do is, there is a format prepared where we have to get the signature of the petitioner, respondent, applicant, and all those things, and then signature of the referral judge, which is this court, and the matter will be, listed for mediation. A mediator will be appointed, and thereafter he will contact the parties, and mediation will, will start. Then after mediation, if the matter is not settled, it will not affect the parties. No adverse inference will be drawn against any of the parties. The matter will simply come back and proceed.
Agitate on merits.
Proceed before the court. So that is basically the idea here. So as far as this item number 12 is
12,
concerned.
13, 14.
But of course, because this court is well aware of the issue
Status
here,
and issues.
whether this is a fit case for mediation.
Because my humble submission, Your Lordship, is that the matter now it's in the compounding stage. Once everything is through, Your Lordship, then the matter also is closed.
Yes, I think. Where is the scope for mediation, perhaps? So what do we do?
And on last occasion, Your Lordship, the matter was fixed, and Your Lordship was pleased to fix after 6 weeks. So adequate time is there also, Your Lordship, to.
So we see that matter is not,
Firstly, we'll try the compounding. Once it is done, Your Lordship,
not suitable for mediation. Not that it's not suitable for mediation, but another recourse has been taken, which would would deal with the issues of the parties accordingly. When this matter was called up, parties have been explained as to the process and benefit of mediation. However, facts and circumstances of the case would reveal that the parties have already taken recourse to another form of settlement by way of compounding of offence by the competent authority. Therefore, it would serve no purpose if the matter is posted for mediation. It is the submission of the learned counsel for the parties that the previous orders passed by this court in this regard may be adhered to for the time being. Accordingly, this matter is deemed not proper for mediation at this point of time. The case will retain its position in the list. Same date will be
Your Lordship, 12, 13, 14.
13, 14. Oh.
Obliged.
Item number 15.
Lordship, 15 and 20, item number 20 are connected matters, Lordship.
Let's go first to 15.
15.
15 and 20.
Who's for the appellant?
Lordship, the counsel from Guwahati.
In item 15, Your Lordship, the counsel is from Guwahati, Your Lordship. In item 15, she's one of the respondent, Your Lordship.
But there's a different. It may. You see, it may have some connection with the issue to be discussed or to be decided.
Yes.
As far as the award is concerned, whatever, or the impugned judgment is concerned.
Yes, Lordship.
But then these are two separate cases.
Lordship, in item 15, Lordship, I have also challenged the judgment because it was on.
We'll go one thing at a time. In item 15, you have filed your cross appeal, isn't it?
Yes, cross appeal, Lordship, and that we have also challenged that the award was not in a proper order, Lordship. And
we will not see here.
Have not
we are,
gone.
see, as far as mediation is concerned,
Lordship.
we are not going to the facts. We are not going to merits. We are just going to the possibility of whether the matter can be settled amicably between the parties outside court.
Lordship.
So that is, to that extent, the court will, refer the matter for mediation. But this is not the stage for, agitation on merits.
Lordship.
So what?
Your Lordship, in item 15, the counsel for the appellant is not appearing, Your Lordship.
This case is listed on 31st.
31st, Lordship, for their reply.
We will see on 31st how it goes. In this appeal, apart from the primary party, that is the appellant herein, who is not represented today, one of the respondent herein, that is the National Highway Authority. You are the National Highway Authority?
Lordship.
National Highway Authority of India has referred a cross appeal. However, in absence of the legal counsel for the appellant, no effective order can be passed today. Accordingly, this matter will now retain its position in the list.
Much obliged.
Item number 16.
Let it come.
Yes, Mr.
My lord, this is that Shillong Club matter, which Lordship has almost heard finally. There is just my reply to be submitted. My lord, the matter is, Lordship is aware of the matter. They want 6 acres of our land. We are willing to give them nothing, no acres. My submission would be that I don't think a settlement is possible in this case, subject to what they say.
There's no scope.
This will have to be again. See, as far as mediation is concerned, it has to be consent of both.
My lord, my lord.
If one party is not agreeable, then matter ends there.
My lord.
And this matter come in the usual list.
Mr. S. General appearing for the appellant, as well as Mr. Leonard Counsel appearing for the respondent, has submitted that the stage of this case is at the fact end, and as such, it would serve no purpose if the matter is referred for mediation. Be that as it may, it is also the view of the Learned Counsel for the parties that this matter is perhaps not fit for mediation. Accordingly, the matter will now be taken up in its usual course.
Item number 17.
Yeah, please, Lordship. Lordship, this matter also, same order may be passed, Lordship, subject to my learned seniors.
Well, this is that
But
element.
this is a matter of enhancement.
Well, so this matter, Lordship has already heard us.
What is the impugn order here?
Well,
What is the impugn order here?
Well, the enhancement which was sought for, that was given to us. 800 rupees was allotted to us as an enhanced amount, my lord. Against that, they have come before this honorable court, my lord. Land is in Plus Bazaar, my lord. On the opposite, if you, my lord, recollect, it's opposite Bata, my lord.
Yes, yes.
The bank where the bank is at. We were given 80 rupees a square feet, my lord, as compensation, my lord. So we had filed for enhancement, and subsequently 800 rupees was given. And a few houses were there, old Assam type. Some amount was given for that also, my lord. Plus interest as per the old act, my lord.
Old act.
My lord. Against that, they have come for this honorable court, my lord. Only 800 rupees was given, my lord. That also plus bizarre, my lord. In spite of that, they have challenged the.
But you have not filed an appeal against the award.
No, my lord. They have filed the appeal.
So you are satisfied?
I'm satisfied with the award, my lord. The bank has preferred the appeal, my lord.
As far as our instruction is concerned, Lordship, no scope for mediation, Lordship.
Mr. Legal Counsel, speaking for the appellant herein, has submitted that he is instructed by his client that the party is not willing for this matter to be posted for mediation and would rather prefer that the matter be heard on merits and to be duly adjudicated by his court. Accordingly, matter will now be listed in due course.
Obliged.
Item number 18.
May it please, Your Lordship. Your Lordship, we are open for the matter to be taken to mediation, Your Lordship, but it's up to the other party respondents.
Lordship, we're not willing to go for mediation, Lordship. We'd like to proceed with the matter, Lordship.
You're not willing?
No, Lordship.
Your Lordship, if that's the case, then let the hearing come up in a few days, Your Lordship.
It will come in due course.
It will come in due course.
As and when it is listed. This letter counsel for the petitioner has indicated that our client is willing to go for mediation if this matter is referred for the same. However, Mr. M. L. Longpure, letter counsel for the state respondent, has submitted that the state is not agreeable to settlement of this matter through mediation. Accordingly, since there is no consensus in the matter, mediation is not possible at this point of time. Matter will retain its position in the list.
Acknowledged, Lordship. Item number 19.
May it please Your Lordship, this matter can go for mediation.
We can try for mediation, my lord. This is
both private parties are involved here.
Yes, my
private
lord.
parties.
Yes, my lord.
It's a money suit matter.
Okay. Both the parties have indicated that they are willing for this matter to be taken up through mediation. Accordingly, the matter is now referred for mediation. I took you. Accordingly, on the forward referral order being duly filled up, the parties will be intimated as to the commencement of the mediation. See, there's a format here.
Yes, my lord.
But it has to be signed by the
Yes, my lord.
by the parties themselves.
Yes, my lord.
Not by council. Or I don't know whether see there is no Court Master will get back to you.
Yes, my lord.
Just confirm this, whether it can be signed by a lawyer representing the party or it has to be signed by the parties themselves.
Yes, my lord.
Because there is a format here.
Yes, my lord.
We have prepared the format and this to be signed by all parties, including the judge. So we will not do that, but this order will remain.
Yes.
In due time, we will contact you.
Yes, yes, my lord.
So, you can name
Highly obliged, my lord.
Item number 20.
What about this?
Lordship, it can be sent for mediation, Lordship. It can be sent for mediation, Lordship.
Who are the parties involved here? And who are you?
I'm the claimant.
The claimant.
My decree was passed in my favor, and I had filed an execution case. After they have agreed before the trial court, now they've come and appealed against the judgment, Your Lordship. Your Lordship was had heard the matter.
Yes, I think first, I think in this matter, the condonation application has to be.
Yes, Lordship. Condonation application is pending, and also, Lordship, for I am to file, Lordship, necessary affidavit to bring on record, Lordship, for the reasons of the condonations, to admit the condonation, Lordship. Some documents are to be filed by me, Lordship, as an additional affidavit, Lordship.
Now, in the meanwhile, it has been listed for mediation.
Whether we can, what is your view?
My only view is that, Your Lordship, if it has to be settled, then they have to pay me whatever the amount is due to me.
But Lordship, here we have, actually, Lordship, since it is listed for mediations, that is why we are like just to help the parties to come to a mediations.
But are you see, are you seriously contesting the award?
Lordship, yes, Lordship, I am seriously contesting because they have in the award, Lordship.
You are not satisfied with the enhancement. It was enhanced, isn't it?
Lordship. Yes, Lordship. And Lordship, enhancement was actually, since in this, it is only listed for mediation, we cannot go into the merits, Lordship. But Lordship, in the award was, the award by the learned special judicial officer has passed without taking into consideration that the award was not lying with them, Lordship. The list of the awardee where. So it's on. It's
now the issue of that condonation of delay application has.
That is pending now. Before going to the merits, first they have to satisfy this court whether the condonation can be allowed or not.
For the purpose for that, because I am to file my affidavit also, Lordship. In the meantime, it has come up for mediation, Lordship.
Anyway, we are still new here, so perhaps
but it will.
The office also are not, the registry rather has not gone to the the factual aspect of this matter. What is the position of the case?
Lordship.
Now, first we have to decide on condonation. That cannot go. That cannot be. Mediator cannot decide.
Yeah, absolutely, Lordship.
Absolutely, Lordship.
Only when the matter is at the stage of hearing.
Hearing.
And only merits to
on
be
merits.
Determined. Then
Lordship.
They'll have to cross the hurdle first of condonation.
Another fact and circumstances of this case, it appears that this case is not yet ripe for referral to mediation. Accordingly, matter will retain its position and list.
Second call, item number 9.
So, who are the parties? All the parties are here.
Yes, sir.
You are willing for mediation. Mr. Debnard, you are appearing. When this matter was called up, parties, learned counsel appearing for the respective parties have indicated that they are willing for this matter to be referred for mediation. Accordingly, the same is referred to mediation, and parties will be informed accordingly when the mediator is when a mediator is appointed as far as this matter is concerned. So you'll be informed. Again, that format is there.
Yes.
We'll prepare the format, and then
we'll try our best.
We'll set it to you, and then once the mediator, is is appointed, he'll inform you.
Yes, very grateful.
Format.
Second call, item number 10.
I don't think we'll have time today because I have to sit in.
Lodge.
Fix it on Monday.
Monday would be 28 Lodge.
Monday, Mr. Hera?
Monday, Lodge.
You are okay with Monday?
Right.
Mr. S.S. Yadav, letter counsel for the petitioner, has submitted that the petitioner has filed the rejoinder to the affidavit filed by the state respondent. It is prayed that this matter may be now posted for hearing. Accordingly, as prayed for, this is matter on 28.
Obliged, Lodge. Good day.
Lodge.
Just a